NTA Blog. Giving taxpayers a voice in IRS appeals conferences. When taxpayers disagree with the IRS, they should have access to a fair and independent review. For many, the IRS Independent Office of Appeals offers the best opportunity to resolve a dispute without the cost, stress, and delay of going to court. But independence must not only exist. Taxpayers must be able to see and trust it. Under current IRS guidance, appeals has discretion to invite employees from IRS compliance or the Office of Chief Counsel to participate in part of a taxpayer's conference, even if the taxpayer objects. Although recent guidance adds helpful safeguards, including advance agendas and limits on participation in settlement discussions, the final participation decision still belongs with appeals, not with the taxpayer. H.R. 8134, the Strengthened Taxpayer Rights Act of 2026, would change that. The bill would require a taxpayer's consent before any IRS employee outside appeals could appear in the taxpayer's appeals conference. This is a narrow but important protection. It would not prevent appeals from preparing thoroughly, requesting legal or technical assistance, or reviewing the case file. It would simply give taxpayers a voice in deciding who is present when they make their case. That matters because the presence of employees from the IRS functions whose position is being challenged can make a conference feel like a continuation of the dispute, not an independent review. H.R. 8134 supports two fundamental protections in the Taxpayer Bill of Rights: the right to challenge the IRS's position and be heard, and the right to appeal an IRS decision in an independent forum. The proposed bill is also consistent with my 2026 Purple Book Legislative Recommendation No. 36, which recommends requiring taxpayers' consent before allowing IRS counsel or compliance personnel to participate in appeals conferences. Appeals plays a critical role in resolving tax disputes fairly and avoiding unnecessary litigation. Enacting this bill requiring taxpayer consent would strengthen confidence that appeals is independent, impartial, and worthy of taxpayers' trust. Key takeaway: taxpayers seeking an independent appeal should have a say in whether non-appeals IRS personnel participate in their conference.
The audio version of the NTA blog is created using AI for conciseness and a computer-generated voice. Although reviewed by a human, inconsistencies in context, pronunciation, and tone may occur. The views expressed in this blog are solely those of the National Taxpayer Advocate. The National Taxpayer Advocate presents an independent taxpayer perspective that does not necessarily reflect the position of the IRS, the Treasury Department, or the Office of Management and Budget. NTA blog posts are generally not updated after publication. Posts are accurate as of the original publication date.